Hello everyone, this is MAHEK. Welcome back to our channel. Today's topic of discussion is more or less kinds of evidence. So we'll be beginning with what this video will be in two parts. First part will be dealing with four types of evidences that are oral, documentary, primary, and secondary. The other part would be dealing with real evidence, hearsay evidence, direct evidence, and circumstantial evidences. So let's start with our classification with oral evidences. All the statements, all the gestures, anything said, anything pretended, anything directed, all these forms are the examples of oral evidences. Oral evidence can be anything that is unwritten. Why unwritten? Because the documents that are produced, uh, the documents they sustain for a period of time, while the oral evidences vanish with the time. Or we can say they don't have that they don't have a they don't have antiquity in them. They are the spontaneous statements of the victims or the witnesses of the accused or any other person before the magistrate. For these oral evidences to be considered as an evidence, as a piece of substantive evidence, it is mandatory, or it is need to that the statement needs to be made before the magistrate and not before the third party. Further, if a person who is not able to communicate, maybe some throat problems or maybe some speech problem or some lingual problem or any other such problems, in that case the gestures he made, and if those gestures are sufficient to make a chain with the facts and issues, or those gestures are falls in the category of relevant facts, then those gestures are included in the oral evidences. Oral evidences has been defined under section 65 of Indian Evidence Act. It says that any evidence, that is any statement section 119, it talks about the oral evidences, and it basically talks about the evidence given by those persons who are not able to communicate themselves by due to some medical deformities or some any other problem. Then we have documentary evidences. As the term indicates, anything written in a documented form is termed as documentary evidences. They are, for example, the records, the registers, or the paper, any paper, the court paper, home paper, anything written, any even a phone number written on a paper constituted documentary evidence. Any formal or informal document can constitute it, but it's not that every document found at the crime scene or any the place of accident or incident, that every piece of document would be considered as documentary evidence. For the court to consider a document as a piece of evidence, its content needs to be proved. It's the credibility of the document needs to be proved. How this credibility is proved? It is by producing two types of evidences. First, either the primary or the secondary. What the primary evidences are? Primary evidences are the real documents. Real documents mean the original copies. If the paper is written, if the number written on the paper is of the writing belongs to accused, and that paper was intercepted from the crime scene, that paper, and it is not the copy, the writing is the original, the piece of the paper is original, then it is a primary evidence. The registers, the register the accused made, the entry in the register the accused made, or or the witness, or the or something, or like the papers, the papers of the registry, the original copies. They all are the examples of evidentiary evidence belonging in the category of primary evidences. Then what are the secondary evidences? Secondary evidences are the copies of these primary evidences and are only admissible when the primary evidences are not available, or are in the possession of someone who is not willing to cooperate to give that or to produce that original copy. So secondary evidences, so as I said, they are the original copies. They are the copies of original document. So so that's all about these two things. And section 65 talks about the secondary evidences, and it laid down some criteria or circumstances only only when they occur, the secondary evidences would be admissible. Else secondary evidences do not have any evidentiary value in the presence of the primary evidences. So that's all about the types of evidences. Hope you like the video. Do like and subscribe the channel. Thank you.